Today I welcome all of you on Legal Training Center, and today's topic is on the demand of various lawyers. What is cognizable offense and what is non-cognizable offense? We have to first of all look into Criminal Procedure Code about the definition of non-cognizable offenses, which is provided in definition section 4N. Non-cognizable offenses. Those offenses in which police cannot arrest without warrant, and cognizable offenses are defined in section 4F, in which police can arrest without warrant. Now question is, what is the basic difference between the non-cognizable cases and cognizable cases? First of all, in non-cognizable cases, there is the requirement of a complainant. There must be a complainant. He should make a complaint about the commission of offense to the station house officer SHO. Under Police Rule 24 Chapter Subsection 3, first of all, he will enter into daily diary the complaint of the complainant, and thereafter he will forward the same through complainant to the Ilaka magistrate, to the judicial magistrate, and these whole proceedings will be under 155(1) of Criminal Procedure Code and 24.3 of police rules. Thereafter, the magistrate will allow under section 155(2) that permission is a necessary requirement, otherwise that will be violation of the law. Under section 55(2), he will permit to carry on the investigation, and after this police officer will go under section 156 to investigate the case, which is prerogative even in the cognizable cases, where only police officer, after registration of case under section 154, which is the mandatory duty of the SHO to record the statement of any complainant, any aggrieved person against commission of cognizable offense, and that is mandatory. But in non-cognizable offense, that is not mandatory. He cannot register an FIR, and only he can register FIR in cognizable cases. Further, from where we can search the offenses are cognizable and they are non-cognizable, that is very clear in schedule which has been provided under CRPC. In third schedule, there is the total schedule of the offences in which police officer cannot arrest without a warrant, and in schedule 4, that is about the arrest without warrant. Now question arises, when commission of cognizable offence is made out, then police officer, any investigation officer, SHO, he is fully authorized, competent, and he don't need no warrant from any concern to arrest the accused, to arrest the culprit, to arrest the offender, any kind of offender. But in the non-cognizable offences, he has no authority. What is the law about it? If in non-cognizable offences, police arrest without warrant, without permission of the magistrate, then the case will be totally against the law, against the power of the police officer, and in this regard, various authorities are from the higher courts. For example, PLD 2005, Lahore 637, PLD PCR in the 2004, page 387, that any police officer who has arrested any person without a warrant in the non-cognizable offences, they were quashed, either they were accused or acquitted under section 249A by the magistrate. Further, if there are both offences, one is non-cognizable and one is cognizable, then what will be the procedure? Then there is no need of any arrest warrant, any permission to investigate for to the investigation officer. Further, after completion of investigation, there is also requirement under section 155(3) to get the warrant from the magistrate. Otherwise, he cannot arrest the warrant. There are a lot of authorities which we can and you can visualize and you can read 2017 PCRLJ Karachi 1, 2 and 2018 MLD page 196 and 2017 YLR 419. These are all with regard to the non-cognizable and cognizable offences. Further, non-cognizable offences are not much serious offences. They are to some extent trivial kind of offences, but cognizable offences are serious offences in which, like murder, burglary, dacoity, death, or you can say in hard cases 324 attempt to murder. But in non-cognizable offences, you can set all these offences as some of them may be of assault or trivial offences. They are non-cognizable offences. In cognizable offences, police can arrest under section 54 and can investigate under section 156 of Criminal Procedure Code. What is the meaning of investigation? That has already been defined in previous lecture. That means the collection of evidence. They can collect in both non-cognizable and cognizable cases. They can collect evidence, and further, after all, they have to provide all the result of investigation under section 173 to the Ilaka magistrate, and further he will proceed as according to the trial, the chapter from which we can visualize the trial procedure, trial before magistrate and trial before session court. So I think that you must be clear in mind what are the non-cognizable and what are the cognizable offences, from where we can search. They can be searched from the schedule provided by the Criminal Procedure Code. One of them, in one, police can arrest without warrant. In one, police can enter into investigation. In second, in non-cognizable, police cannot arrest without warrant, cannot investigate, cannot register the FIR under section 154. All requirements are necessary, mandatory. Without permission of the magistrate, police officer cannot do any of the function as mentioned above. So I think that is sufficient, and you can visualize and you can analyze these all authorities which are provided in this lecture. Thank you very much.